Well, the Chattanooga school bus driver behind the wheel during a deadly crash is refusing now to talk to federal investigators. Jonathan Walker declines to be interviewed on the advice of his attorney. The National Transportation Safety Board says Walker slammed his school bus into a mailbox and utility pole last week. The bus then rolled onto its side and collided with a tree. 6 students were killed, more than 20 hurt. Monique Pressley is a trial attorney and criminal defense attorney. Wendy Patrick is a veteran prosecutor and trial attorney. Monique, we know you have the right to remain silent, but in a case like this, is there no requirement that he speak to federal investigators?
No, there isn't, and no one can argue that this is a truly tragic and horrific situation for the families, for the community. However, our Constitution says what it says for a reason, and Mr. Walker does have the right to not incriminate himself by the things that he may be saying when you're looking at what may be very serious charges. Intentional murder, if they find out that there was something seriously going on with him at the time, or if he was asleep at the wheel, or if he was drug-induced, or who knows what it could be. It could be a negligent homicide charge for those innocent children who were lost. So his attorney is rightly advising him that at this point it is probably best for his own legal prospects for him to remain silent.
Wendy, it's all about leverage. Do the feds have any leverage that they could apply to get him to talk?
Well, he doesn't have to talk. You know, as Monique and I deal with every day, there's the reality that they don't need him to talk to build a case against him. We've officially moved into black box mode in terms of this investigation. We've downloaded, and I say we broadly, the investigators that are looking at that case, they've downloaded the video recording, the audio. We don't know what's on those tapes, but we do know that they're being poured over by investigators. And based on what they find, it may very well indicate that there's going to be a higher charge. When you're looking at a case like this, John, motive matters. In other words, did he do it intentionally? Was it an accident? Was he doing what we call a DWT, driving while tired? Those are questions that could very well be answered simply by looking at the circumstantial evidence surrounding this crash.
The Chattanooga Times Free Press talked to a teacher at the school who had ridden along with this particular bus driver because there had been reports that he was, well, not good behind the wheel. This teacher said the driver was now visibly upset and continued on by saying that he had another job. Driving this bus was just a part-time job for him. He then stated, "Or I can just leave the student on the bus and I will get off the bus and leave the school." Driver stated that he did not care about the students and proceeded to tell the students he did not care about them. Again, that's a teacher at the elementary school where so many of these children attended. Monique, that sounds like pretty good evidence for the prosecution in a case like this.
Well, it certainly does, if that's what the witness testimony shapes up to be, but it may be the case that there's a medical history or background that's involved with this soon-to-be criminal defendant in this case. Those are all things that, as you know, we're going to have to figure out with time as the evidence comes to light.
What about this, Wendy? They are asking for his medical records. The court is subpoenaing his medical and mental health records. Now, what if it turns out that this guy were bipolar or something? I mean, pick your mental illness.
Right.
If you apply for a job as a bus driver, shouldn't that be something that you would be required to disclose?
John, this is such a tricky area because on the one hand, everybody's bound by discrimination laws. You can't discriminate against somebody for different types of disabilities, particularly if they are controlled. The reason they're looking at that kind of evidence in this case is this is a case where he caused the death of 6 children. I mean, our hearts grieve for that community and for the families of those victims. So obviously they want to know whether or not he was fit to be driving that bus. And why was he speeding? Why was he off his route? This is the kind of circumstantial evidence that is routinely gathered in cases like this. But here's the caveat, John and Monique. As we know, it doesn't mean that it's going to be admissible. You talked about all the hearsay statements flying back and forth. Same thing. So what they can gather surrounding the crash and what will be admissible in a courtroom, 2 very different things.
Monique, his attorney has suggested he plans to plead not guilty again. Given the wealth of evidence here, why not just spare the community the heartache and plead guilty and take whatever rap you get?
Well, look, that's what the attorney is saying at this time, and that may change. It may change sooner rather than later if the federal government, if NTSB is leaning on him to testify and offer some sort of deal in exchange for testimony and information, then we may hear that change. But the one thing that I also think is important is that while HIPAA laws protect his medical information, that doesn't mean that the school district isn't responsible for making sure that drivers are driving buses and keeping our children safe who are medically fit to do so. So we may find that the school district is also in trouble because of what happened to these children.
Yeah, there was a private bus company that was hired by the school district. So two different things here, but yeah, the district may end up on the hook for this as well. Monique, Wendy, thank you both.
Thank you.
Thank you, John.